Senator, I believe it is the amendment that deals with a two-term limitation on
Correct.
the service
It
of the
states
president.
no person shall be elected to the office of the president more than twice. Mr. Mark, is President Trump eligible to run for president again in 2028?
Senator, without considering all the facts and looking at everything, depending on what the situation is, this to me strikes as more of a hypothetical of something that could be
It's not a
raised.
hypothetical. Has President Trump been elected president twice?
Welcome back to Freedom Forge. If you're new here, make sure you hit that like button and subscribe, because this is where we break down what's really happening in Washington without the spin, without the media filter, and without the political games. Today, we're reacting to a Senate hearing where lawmakers are questioning judicial nominees and legal experts on constitutional issues, judicial ethics, and the rule of law. What you're about to hear is not just a legal discussion. It's a window into how seriously, or in some cases how casually, people seeking power treat the Constitution of the United States. And right out of the gate, something jumps out that should concern every American who cares about the integrity of our system.
Chair.
Thank you, Senator Coons.
Thank you, Chairman Grassley, and to each of you and your families, congratulations. And thank you for raising your hand to serve and in some cases continuing to serve the public.
Thank you.
Mr. Mark, if I might, just tell me about the 22nd Amendment. What does it provide?
The 22nd Amendment, Senator, my career has mostly been in criminal prosecution. I haven't had an opportunity to use that one specifically.
Anyone able to help on the 22nd Amendment to the United States Constitution?
Senator, I believe it is the amendment that deals with a two-term limitation on
Correct.
the service
It
of the
states
president.
no person shall be elected to the office of the president more than twice. Mr. Mark, is President Trump eligible to run for president again in 2028?
Senator, without considering all the facts and looking at everything, depending on what the situation is, this to me strikes as more of a hypothetical of something that could be
It's not a
raised.
hypothetical. Has President Trump been elected president twice?
President Trump has been certified the President of the United States 2 times.
Is he eligible to run for a third term under our Constitution?
I would have to review the
All I need to
actual
tell
wording
you
of
is
it.
the language of the constitutional amendment that makes it clear that no, he is not eligible to run for a third term. Anybody else brave enough to say that the Constitution of the United States prevents President Trump from seeking a third term? Anybody willing to apply the Constitution by its plain language in the 22nd Amendment? Nobody. All right, let's move on. Mr. Coons, what is res judicata? How does it apply?
It's a judicial doctrine that prevents a judgment that has been, in one case, applies to a, you can't go into court after a final judgment in one case and have it, and litigate the same things again.
How is that distinct from collateral estoppel, which precludes litigating the same things?
Res judicata, one involves the same party, the other involves the same things.
And what's a requirement for these two doctrines to apply?
Notice, opportunity to be heard, final judgment of a court of competent jurisdiction.
Anyone disagree? If I might, Mr. Coons, is it pronounced the same way mine is?
Yes, it
Coons?
is. Yes, Senator.
My family's name was spelled that way when we came to the country. So, you were one of 3 judges on the panel in Alexander v. Trump, where the president was suing the Pulitzer Prize Board for defamation. When did your work on that case begin? When were you assigned this case to decide?
I first learned of that case in approximately January of 2025.
Not when the briefs had been filed?
No, Senator. The way it works in our court is we are not assigned cases when the briefs are filed. Once the case is ready for disposition, the clerk randomly assigns it to the judges on the court.
And when did you first speak to Senator Scott's office about your interest in a district court seat in the Southern District of Florida?
I mean, I've had many conversations with Senator Scott's office. The one about an interest in the Southern District of Florida, I believe, was in November of 2024. I don't know the date, but it's in my Senate Judiciary questionnaire.
And when did you release the opinion ruling in President Trump's favor in this matter?
So I learned of the case in January of 2025, and the opinion was released in, I believe it was February 12th, 2025.
That's correct. So you issued an opinion where one of the litigants before you was the president and in favor of the president while you were in active conversation with the senator's office about seeking a federal judicial appointment. Is that correct?
For a position I did not, in fact, get, Senator.
How did you end up in front of me today?
It's a different position, Senator.
Did you consider recusing yourself from that particular decision?
No, and the canons that govern us in Florida, Senator, as I believe this committee has previously heard, it did not call for me to recuse myself. I did not have an interest in the litigation, and none of the basis called for recusal, and the Florida Supreme Court instructs us, the appellate judges, that we are not to recuse unless one of the bases in Canon 3 exists.
Does the Florida canons not require you to recuse if one of the parties before you has an interest that could be reasonably concluded by any common citizen to cloud your judgment on that matter?
Senator, I disagree with that characterization. I had not heard from the White House until after the opinion was final. I had only spoken.
When did you interview with the White House counsel's office?
At the end of February of 2025. I don't know the date, but I believe it's in my Senate Judiciary questionnaire.
Thank you for your testimony on that matter. Mr. Hendershot, if you would just take a minute and talk me through again how collateral estoppel and res judicata are different from each other.
Senator, I'm not sure I can improve much on Judge Kuntz. I think that often res judicata today is used as sort of a catch-all term, but generally I think the difference is between claims and claims that may have not been brought but could have been brought potentially.
Right.
So collateral estoppel and res judicata is more a thing actually decided, as the Latin would suggest.
Thank you. Do you agree that judges should not be influenced by external pressure to rule in any particular way?
Yes, Senator, I do.
President Trump stated March of this year at a public event, quote, "We have rogue judges that are criminals. They're criminals, what they do to our country, the decisions they hand down and hurt our country. Is it possible for a judge's decision to be correct as a matter of fact and law, even if it differs from the president's desired outcome?"
Senator, I want to tread carefully because of Canon 5 in terms of commenting on political matters. But in the abstract, yes, decisions can be correct, and any citizen can criticize what a judge has done. That is, I think, part of their right to speak.
Thank you. Thank you all for your testimony.
Yeah. Mr. Hen-
You got a sitting senator asking a very basic question about the 22nd Amendment, something that's not obscure, not complicated, not buried in legal theory. This is foundational. The amendment clearly states that no person shall be elected president more than twice. That's it. Plain language. Straightforward. No ambiguity. And yet, when the question is asked whether Donald Trump could run for a third term, you see hesitation. You see people dancing around it, calling it hypothetical, saying they need to review the facts. That's not reassuring. That's alarming. Because here's the reality. If you're being considered for a position that requires interpreting the law, and you can't confidently apply one of the clearest constitutional amendments we have, then what exactly are you bringing to the table? This isn't about being pro-Trump or anti-Trump. Let's be clear about that. This is about whether the Constitution means what it says. And if we start treating clear constitutional limits as hypotheticals, then we're opening the door to a system where the rules only apply when convenient. Now, the senator pushes further, and what happens? Silence. Nobody wants to step up and simply say what the Constitution already says. That tells you everything you need to know about the political climate in that room. People are more concerned about optics, about who they might offend, about future career prospects, than about standing firmly on constitutional ground. And then the hearing shifts into legal doctrine, residential judicata, collateral estoppel. These are important concepts, no doubt. They deal with finality in the legal system, making sure cases aren't endlessly relitigated. Fine, that's legal mechanics. But here's what stands out. They can confidently discuss complex Latin legal doctrines, but struggle when asked to apply a basic constitutional rule. That disconnect should bother you. Then things take another turn when questions arise about judicial conduct. One of the nominees ruled in favor of President Trump in a case involving the Pulitzer Prize Board, all while being in active conversations about a potential judicial appointment. And when asked whether he considered recusing himself, the answer is no. Now, think about that for a second. Even if technically allowed under certain judicial canons, the question isn't just legality. It's perception. It's trust. It's whether the average American can look at that situation and feel confident that the decision was completely free from any external influence or personal ambition. That's the standard we should be holding judges to. Not just did you follow the rules, but does this inspire confidence in the system? And this is where the conversation becomes bigger than just one hearing. This is about the erosion of trust in institutions. When people see hesitation on basic constitutional questions and potential conflicts of interest brushed aside, they start to wonder whether the system is still working for them. Then comes the discussion about judges being criticized. The senator brings up comment from Donald Trump calling some judges rogue and even criminal. And a response from the witness is cautious, almost walking on eggshells. Here's the truth. In America, criticizing judges is not only allowed, it's part of free speech. But at the same time, we have to maintain respect for the rule of law. There's a balance. Judges must be independent, and their decisions must be based on law. Not politics, not pressure, not public opinion. But independence goes both ways. It means resisting political pressure from the left and the right. It means making decisions that may be unpopular but are legally sound. And it also means being transparent and beyond reproach in your conduct. What we're seeing in this hearing is a system under strain. You've got political pressure, career ambition, and legal responsibility all colliding in one room. And not everyone is handling that pressure well. As a right-leaning patriot, I'll say this plainly. The Constitution is not optional. It's not flexible depending on who's in power. It's the foundation of this country. And if the people tasked with interpreting it can't stand firmly on its most basic principles, then we've got a serious problem. This isn't about scoring political points. It's about preserving a system that depends on clarity, consistency, and courage. Courage to say what the law actually says, even when it's uncomfortable. Courage to step aside when there's even a hint of conflict. Courage to uphold the Constitution without fear or favor. Because once that courage disappears, what you're left with is a system driven by convenience and politics. And that's not the America the founders envisioned. So as you watch hearings like this, don't just listen to the words. Pay attention to the hesitation, the deflection, the moments where clarity should exist but doesn't. That's where the real story is. If you believe in the Constitution, if you believe in accountability, and if you want more breakdowns like this where we cut through the noise, make sure you like this video and subscribe to Freedom Forge.